For the record, this matter is before the court on the defendant's motion for order to show cause. This hearing is being conducted via Zoom. The defendant moving party, Sheila Hall, is present. In addition, Attorney Stephen Jednick is present representing the plaintiff, Derek Verley. Mr. Jednick, you'll be filing an appearance. Is that correct?
I've been the attorney on this case right along the last year. I assume with the short turnaround, my appearance still continued, but I've been the attorney of record since the beginning.
Okay. That's the challenge of family court cases. If people are attorneys are on a case for one limited appearance and then they're off. But in any event, Mr. Jednick is present on behalf of the plaintiff, Father Derek Verley. Good morning, everyone.
Good morning.
Good morning.
The parties have conferred with Mr. Walker this morning from the front of the court. Mr. Walker has provided the court with fine recommendation that the mother shall personally provide the breast milk to father when he picks up the minor child. Of course, this is frozen breast milk, so dad's got to make sure he's going, it's in the freezer. If any third party is going to pick up the minor child, that was issue with the grandparents. So if any third party is going to pick up the minor child, and works both ways, the party shall communicate through AppClose who will be picking up or dropping off the child. If either parent has the minor child for over 24-hour period, the other party may ask for an update via AppClose regarding the minor child up to 2 times within that 24-hour period at reasonable times. And lastly, that this resolves the motion for to show cause. It's just a matter of communication, Mr. Verley and Ms. Hall. In any event, Mr. Jednick, this recommendation will be with your client this morning.
It is. We accept.
Ms. Hall, do you understand the recommendation?
I understand it. I don't agree with me having to give him the breast milk since I'm in my own classroom and he's never had a problem with opening the fridge that's in my son's classroom and grabbing it. They always tell him it's in there.
And I'm sorry, in the past, you've always handed it to him. What if you're busy or tied up or something?
So I don't work in my son's classroom. He has 3 teachers, and the fridge freezer is in his classroom, and they tell him, Derek, the breast milk is in the fridge.
Okay.
So I don't understand why I have. I'm sorry.
The problem you're sometimes you type it in a class when he picks up the child.
I'm in my own classroom, yes, and at this time it's rest time, and I'm always in the classroom at rest time, and I can't just leave my sleeping children to go give him breast milk. Okay,
well, that's a legitimate issue, Mr. Jednick.
And the reason why the recommendation came into place was that there's times where there's breast milk isn't there. So the whole point that was recommended was to alleviate the back and forth of who got it and who didn't get it. If Ms. Hall was giving it personally to Mr. Verley, that's going to cut out the did he get it? Did he not pick it up? Because sometimes the breast milk isn't there, and that's a contention against Mr. Verley. And we're just concerned about him being accused of violating a court order if the milk wasn't there in the first place. But the handoff will stop all that, especially given the current communication issues with the parties.
Right. Ms. Hall, do you have a refrigerator in your classroom?
I do not.
Okay.
It's always in my son's room, and I'm going to let you know that I didn't give milk to him once because I didn't have it to give it to him. So all the things that he's done, he's never gotten in trouble for, but I'm being blamed for not giving him milk once. And I did tell him that. I let him know in the app. I do not have
no one's blaming anyone for anything. Let's just straighten this out. What makes the most sense for both of you? There's enough challenges in life. Let's make life good for each other. Obviously, if she can't leave the classroom and give them the milk, then that's an issue, Mr. Jednick. We need to address that. And I thought the primary issue was the third parties, like the paternal grandparents, pick up the child and not checking the freezer.
It was. This came up during the course of talking in front of the court. So, I mean, and the child's weaning off breast milk. We're hoping this isn't going to be an issue for too much longer. But no, that was to protect Mr. Verley from the allegations he didn't pick it up. If she's handing it to him, that's going to nip that in the butt. So unless she's going to back off on those allegations going forward, especially as Braylon transitions out of breast milk, we're just trying to protect him.
Well, any reason why even picks a child, he can't just check the freezer? Obviously, I'm sure it's labeled.
He's done it before, Judge. He had no problem opening the fridge, and the teachers always let him know that there's breast milk in the fridge. There was breast milk in the fridge the whole time last week. It was 1 6-ounce frozen block and he never took it. So I put that frozen block in with the other 6 frozen blocks for last weekend, and he even refused to take that. He said, my son drinks formula when he's with me. And I can even have the teachers come in and talk to you if need be.
And the staff doesn't inform, and we're dragging a bunch of third parties in here to police the breast milk. If she hands it to him, that kills the issue. And
right,
again,
Mr. Jenner,
we have a child weaning off breast milk. So,
Mr. Jenner, she can't leave the room she's in. She can't leave children unattended to walk to Mr. Really. So either we change the parenting time pickup, or he goes to the freezer to pick it up. I mean, I'm just trying to be common sense here. I mean, why wouldn't he check the freezer?
And he checks it. I mean, if we want to do, she sends a snapshot or some communication saying, "Hey, milk's in the freezer." That might do it too.
Can't we assume there's milk in the freezer every day? He picks up the child.
You can, but if she's not, she indicates she's having difficulty producing. Some days there might not be. So maybe she just needs to take a picture or communicate that. Then he knows to get it. Then it's on him.
Is it that difficult just to check the freezer?
Apparently.
Hold on, Miss Hall. Mr. Jenick, is it difficult for Mr. Really just to check the freezer?
Not at all. But again, if he checks, I don't
Right.
want the allegation that he wasn't informed there's milk there or that he didn't look or something like that. So if she says, "Hey, it's there," especially now that she's weaning off of it, then he's on notice to get it, and that's on him if he don't. That's what I'm saying.
Well, again, and until I guess when you're no longer providing breast milk, Miss Hall, you should notify Mr. Verley. But in the meantime, Mr. Verley should check the freezer every day.
And it's always been in the same place, Judge. It's always been in the top part of the freezer. There's always, I mean, in the beginning it was 2, and now it's only 1.
All right.
And lately it's been, I'm doing, I will give him a block of 3-ounce because where I am, my body's not producing as much.
All right.
So he's been mixing 3 ounces of formula.
All right, the court's going to modify the recommendation, Ms. Hall and Mr. Jadnak, Mr. Verley, that father shall check the freezer in the child's classroom every time he picks up. And Ms. Hall, when you're no longer producing breast milk and you're not providing it, notify Mr. Verley so he's not looking for it when in fact you're not providing it. So the court will assume that, hold on, the court will assume that you're going to put it in the freezer every time that dad picks up the child, unless you tell him otherwise. He's going to check that freezer. Okay?
Yes, I will. I have no problem with that, Judge.
So, Mr. Walker, good morning. If you could just change maybe that first sentence, the recommendation that father shall pick up breast milk from the freezer in the child's classroom when he picks up the child. What about the remainder of the recommendation, Ms. Hall, that if any party, third party is going to pick up the child, the party shall communicate if the applicant who will be picking up or dropping off. And if either parent has a child for more than 24 hours, over a 24-hour period, the other parent can ask for an update regarding the minor child up to 2 times within the 24-hour period at reasonable times. Are you any objection to that provision?
I mean, I would prefer if Derek is the only one that picks up, but
and sometimes the reality is sometimes we're all busy, so it's not unreasonable as long as the child. Well, obviously it's still a young child, but as long as it's a person that you're comfortable with, it's not some. We're talking in this case, it's grandparents, right?
But they don't like me. They don't even want to have communication with me, and they didn't even want to let me know that they had my son when Derek refused to tell me where my son was.
Mr. Verley, that's on you. You need to communicate. You need to communicate with the mother of your child. Otherwise, you're going to have a very difficult 18 years. You'll be back in court. You need to communicate. Have you both completed the SMILE program?
I'm sorry, what?
Have you completed the SMILE program? SMILE, Smart, Start, Make It Livable for Everyone.
No. I don't
No.
think that was ordered.
Okay,
No.
the courts can order Mr. Walker, both parties shall complete the SMILE program, and we'll provide you with instructions. It's an acronym for Start, Make It Livable for Everyone. You need to learn to co-parent.
I know how to co-parent, Judge.
Ms. Hall, the court can order you, both of you, to complete the SMILE program so you can communicate better. And yes, it's not unreasonable for grandparents now, but some third party that that you don't know who it is, Ms. Hall. Obviously, if it's other than grandparents, you should inform the other. And this order says you shall communicate who's going to pick up the child. If in fact you have a problem, Ms. Hall, and you don't know this person, then they bring it back before the court. Should be parties that know the child. And yeah, grandparents is appropriate. But again, you may need some help in the future too, Ms. Hall, transporting the child and rely upon your parents. So it's not unreasonable.
What I think is unreasonable is if when I try to get in contact with them and they ignore me on purpose. Like it takes 2 seconds to tell me, yes, your child is with me and he is safe and he's fine.
That's Mr. Verley, you respond. When you get a text from Ms. Hall, you need to respond promptly and timely. Do you understand that?
With reasonable text.
Yeah, I understand that. Yeah. Sorry.
Okay, I mean, it's a common courtesy. And no different than when you can't reach the child, you have no idea where your child's at, and Ms. Hall refused to communicate with you, respond. It's a little frustrating.
I shouldn't have had to do a welfare check on my child.
And that was an overreaction. That's an abuse of police resources. She uses the police all the time. Well, that's her right.
No,
she's going to make false reports of kidnapping to get the police out there. That's a problem, and she needs to be cautious.
Well, we reach out to Dad and Mr. Verley. You should time to respond. It'll eliminate the need for these welfare checks. The court agrees that the police have more important things to do, but Mr. Verley should timely respond.
Judge, the only reason why I did it is because Derek normally responds to me, and I had not heard from him. I had got a hold of his mom. I had not heard from them. So I'm sorry, but it had been like 20 hours and I didn't know where my son was. The court understands that. And it's probably a legitimate call when in fact, people just refuse to respond to you. They should not respond. And Mr. Verley, I trust you're listening to the court, Mr. Verley, and you'll respond in a timely fashion. Why don't you talk with Mr. Jednick and then you can listen to the court, Mr. Verley. Go ahead. You hear what the court said, Mr. Verley?
Yes, I did.
What did I say?
If I have to communicate at all times,
timely, Mr. Verley. So it's common courtesy. If your parents going to be with the children for the day, that you're going to let them know. You should suggest to your parents too. What if something happens to you later in life? Do you think your parents want to have a relationship with your child? They better develop a relationship with Miss Hall.
I mean,
something happens to you later in life, they want grandparenting time. She's gonna shut them off. So you need to tell your parents that they need to act like adult grandparents as well and communicate with the mother of the child.
Judge, I would really like it in writing in the order that when they have him, they have to communicate with me.
I have no jurisdiction over the grandparents. I have jurisdiction over the two of you and the child. So if Mr. Verley's not going to cooperate, he's not going to respond timely, then yes, we can modify his parenting time, Ms. Hall. That's what the answer is. And curtail his parenting time.
Because I have a feeling that they think that I'm trying to not give Braylon time with them. I don't care. Yes, that's family. I want him to know his grandparents. I want him to know other extended family, but he obviously, I don't know. He has no respect for me. And if it's not written in the order, he doesn't care. He has no common courtesy for me.
Well, I'll bring it back to court if there's a future promise, Ms. Hall, but at this point in time, the court's going to order that father to check the freezer at school for breast milk every time he picks up the child. And again, the remainder of the recommendation, the court will adopt that if any third party is going to pick up the child, the party shall communicate through APCOS who's going to pick it up and dropping off the child. And you do that time, Mr. Verley. If you know you're not going to pick up the child, you need to make sure your parents check that freezer. If if you're not making sure they're doing that, then we're gonna modify parenting time.
Okay.
Because his mom was informed that milk was in there and she refused to take it.
I don't know why she would do that. I mean, you think a mother would appreciate the value of breast milk. In any event, anything further this morning, Mr. Jednick?
No, thank you.
All right, and they were going to add to both parties shall complete the SMILE program. So next time you come to court, that's the first question the court's going to ask. Have you completed the program? So make sure you complete that. Anything further, Ms. Hall?
Are you going to, how is that going to be, sent to me? Like, is it in person or?
Oh, it's online.
Okay.
Mr. Walker will send instructions.
Okay, thank you.
Okay. All right.
That updated recommendation should be in your queue now.
Thank you, Mr. Walker. All right, that'll conclude this hearing. Again, Mr. Verley and Ms. Hall, work together. Communication is the key. Make it good for each other.
I'm trying my best, but he doesn't know how to co-parent.
Okay, all right, that will conclude this matter. We're going to zoom out. Have a good rest of the day. Thank you, Mr. Jednak. For the record, this matter is before the court on the defendant's motion to suspend plaintiff's parenting time, as well as the plaintiff's objection to the ex parte order, which this court entered on June 17th, 2024, suspending suspending plaintiff mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Leah Worker representing the defendant father, Joshua McDonald. Mr. McDonald is present. Plaintiff mother, Blythe Herman, is also present. Good morning, everyone.
Good morning.
Parties have conferred this morning with Ms. Brower from the front of the court, who's provided the court with the following recommendation. That mother shall have phone contact with the minor child at 7 p.m. on Sundays, Wednesdays, and Fridays. Mother shall initiate the calls to the child's phone, a 14-year-old daughter. Further, it's recommended that it's noted that the parenting time complaints filed by plaintiff mother dated June 25 and June 28 be dismissed. That the parenting time show cause scheduled before Referee Hamrick today at 3 p.m. shall be adjourned to August 6, 2024 at 10:30 a.m. with a review of the CPS case and parenting time. The party shall communicate in the interim via app close. The party shall look into counseling options for the minor child that are covered by insurance. Further, it's fine noted that there's an open CPS investigation at this time. The minor child is with dad right now, Mr. Worker, so I think Mr. McDonald should take the initiative to explore counseling options for their daughter that's covered by insurance. He should take that initiative, and he's not already done so. He should be doing that today, making some calls and scheduling an appointment for their daughter so that we can reestablish this mother-daughter relationship.
I agree, Your Honor. The child is covered by insurance by both parents, which was why I believe the reason Ms. Brower recommended that both parties look into that to make the best choice of counselor based on the different insurance coverages.
Okay. And Ms. Herman, if you have some suggestions or recommendations, you should communicate those to make to Ms. McDonald. And Mr. McDonald, once you have found someone, you should review that with Ms. Herman before you commit to that. Both of you should agree on that. All right. Ms. Herman, do you understand this recommendation this morning?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation?
I do not, Your Honor.
I'm sorry?
What they're suggesting until CPS clears the report, I'm okay. I'm okay with that, Your Honor.
Okay. All right, Ms. Rourke, is this recommendation good with your client this morning?
It is, Your Honor.
The only question the court has if we should schedule this matter for review. I understand there's a there's a review set before Referee Hamrick on August 6th at 10:30.
Your Honor, that review is before the court.
I'm sorry?
That review, I should modify my recommendation. That review on August 6th is before the court.
Oh, for this court. Okay, fine.
Yes.
This court would like to review it. I want to see that we're moving forward in positive fashion to reestablish mother and daughter relationship. So, yeah, so that review will be before this court and this court's docket August 6th at 10:30. And I see it's got the court Zoom ID number. Okay. Yeah, so that review on August 6th, you will be coming back to this court, Ms. Herman, in about 30 days to review this. The court wants nothing more. Hopefully your daughter will get in counseling in the meantime, and the counselor can assist in helping your daughter talk through some of these issues so we can reestablish our relationship. And hopefully when you agree upon a counselor, maybe that counselor would, it's up to that counselor whether or not the counselor will include you in those sessions, or whether you need to get a separate counselor. But sometimes you want to obviously get the two, you and your daughter, together in a counseling environment. All right, so with that clarification, this review hearing is before this court August 6th at 10:30. We have that, Andrea? Okay. All right. Mr. Rourke, anything further on behalf of Mr. McDonald this morning?
No, I don't believe so at this time, Your Honor.
All right, anything further, Ms. Herman?
Just that I am allowed to have phone conversations. I believe they suggested Wednesday, Friday, and Sunday at 7.
Correct.
Okay.
And you shall initiate the phone calls to Elizabeth's phone.
Yes, Your Honor.
And Mr. McDonald, you need to, obviously as a dad, you need to also, I mean, your daughter has one mother in this world, and to the extent that you can assist in repairing their relationship, that will behoove and benefit your daughter. So obviously make sure she's available. Let her know that her mom's going to be calling her on Sundays, Wednesdays, and Fridays at 7 o'clock. Make sure she's available and that she'll take that phone call. She owes that respect for mom. There's some issues I work through, but you've got to be supportive and encouraging that relationship, and that she will talk with her mom.
I agree.
With that, the court will adopt the recommendation. We'll put this back on our docket August 6th at 10:30.
Thank you, Your Honor.
All right, that concludes the matter. Your copy of this order will be mailed to you, Ms. Herman.
Herman versus Joshua McDonald.
Record, this matter is before the court for the purpose of reviewing and ex parte order entered by this court suspending plaintiff mother's parenting time. That ex parte order was entered on June 17th, 2024. On kind of an alleged assault of the 14-year-old child by the plaintiff mother. This hearing is being conducted via Zoom. Present is Attorney Leader Worker representing defendant father Joshua McDonald. Mr. McDonald is present, and plaintiff mother Blythe Herman is also present. The court notes that actually when we were last year was July 2nd. The ex parte order was continued, but mother was granted phone contact with minor child on Sundays, Wednesdays, and Fridays. I was adjourned to today's date to determine the status of CPS investigation. The parties have conferred this morning with the assistance of Ms. LaPrade. The recommendation of Ms. LaPrade is as follows. The mother shall have phone calls with the minor child Elizabeth on Wednesdays, Fridays, and Sundays at 7 p.m. It's noted that the child is attending counseling. The party shall follow all reasonable recommendations of that counselor. And the minor child shall continue in counseling. It's further recommended that father be permitted to take the child to Florida from August 14th to August 18th. And the parties will appear back for its court to review parenting time September 4th at 9:30 a.m. That is the recommendation, Ms. Work. Is this recommendation agreeable with your client this morning?
It is, Your Honor.
Ms. Herman, do you understand the recommendation?
I do.
Okay, the court wants nothing more than to reestablish a relationship with you and your daughter. No question, teenagers can be challenging. Do you understand do you have any objection to the court adopting this recommendation?
I would like more availability as far as maybe what the mediator had asked if we could do dinners. I actually reached out to Josh and invited him and his girlfriend to a lunch date with Elizabeth. I'm trying my absolute hardest to co-parent from a distance, and I haven't seen my kid in 11 weeks. I'm heartbroken.
It's not an unreasonable request, Ms. Rourke. What about a daughter having dinner with mom? Dad could drop her off. Mom can, whether it's, she could suggest a restaurant that maybe that Elizabeth likes. Dad could drop her off for a 1-hour meal with her mom in a public place. Any objection to that prospect?
Yes, Your Honor. At this point, there is. My client, Elizabeth, has started counseling. She's only been able to have one session so far, but she is just establishing a relationship with a counselor. This was a traumatic event. There's no dispute as to whether or not mom slapped Elizabeth. By Elizabeth's account, it was hard enough that she knocked her off the bed. Elizabeth is 14, almost 15 years old. She reported to dad that she liked the counselor and is, eager to continue seeing her. But following this event in May, Ms. Herman attempted to essentially gaslight Elizabeth into, all of the reasons why it happened and trying to minimize it. This was traumatic for Elizabeth, and we think that she would benefit from some additional counseling and the support of her counselor and having conversations with mom to address this rift in their relationship. And we think that Elizabeth needs that support in order to be able to do that in a healthy way. There's a power differential here between a parent and a child. And
Court understands all that, Ms. Worka, and understands that. And obviously 14-year-olds can be challenging. I've raised teenagers.
Certainly, Your Honor.
The question is, would if Mr. McDonald, if Elizabeth mom wanted to meet her for dinner, would Elizabeth refuse to attend?
Yeah, right now, yes.
All right. Well, we don't want to force things, Ms. Herman. If in fact, Elizabeth, we don't want to force things. Do you know who the counselor is, Ms. Herman?
Yes.
Talk with the counselor.
Okay.
Talk with the counselor just so you get insight in terms of what you can do in terms of reestablishing a relationship with your daughter. And again, sometimes you need to, and I don't want to put this off. That's where we're getting a review date. The court wants to develop and reestablish and repair this relationship. We've got to do so in a deliberate, careful fashion. And hopefully when we come back, that at least we can maybe have some meals. I mean, talk with the counselor. If she thinks that Elizabeth, now saying what Mr. McDonald said, if she thinks that Elizabeth would be willing to meet you at a restaurant in public for dinner, then there's no reason why we can't talk about that when we come back. But if in fact Dad's saying Elizabeth wouldn't do that, we don't want to force things and create any further problems. What do you think Elizabeth would go? Meet you at a restaurant?
I've asked her a few times and she tells me no every time. So I don't want to push the issue on her.
Right.
If that makes sense.
All right. So the court's not going to force it at this time, Ms. Herman. Mr. McDonald, obviously encourage it. I mean, the best thing you do for your daughter is to tell her that her mom, she got one mom in this world, her mom loves her, and that they just need to work out some of their differences. That's all. And encourage that. Keep an open mind. All right. Anything further than this morning, Ms. Herman?
No, Your Honor.
Okay. We'll review this on September 4th at 9:30. So a month away, and hopefully we can have some personal contact at that time, but do communicate with the counselor.
Yes, Your Honor.
All right. Anything further, Ms. Worka?
No, Your Honor. Thank you.
All right. Go adopt the recommendation, and we'll review this matter on September 4th, 9:30 via Zoom. All right. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Good morning.
What is the CPS investigation still ongoing, or has that been concluded, Ms. Worka, Ms. Herman?
Your Honor, it has been concluded.
Okay. And closed?
It has been closed, yes.
Any recommendations of CPS? Safety plan or anything?
No. There was admission by Ms. Herman that she had slapped Elizabeth because there were no physical injuries. They closed it with a finding of no preponderance.
Okay. Right. And Elizabeth is still engaged in counseling. Is that correct?
Yes, Your Honor.
How often does she attend? Weekly? Every other week?
Typically weekly. There have been some scheduling issues. The counselor was out. I believe the counselor canceled an appointment due to being ill. And we did address an issue of a balance owed to the counselor to get Elizabeth rescheduled. We did address that this morning. Ms. Herman had agreed to take care of that balance to get her rescheduled.
Very well. The parties have conferred with Ms. LaPrade from the front of the court this morning, who has provided the court the fine recommendation that mother shall have parenting time on Saturdays from 1 p.m. till 5 p.m. Mother will provide all transportation. The parenting time shall take place in a public place. Mother shall pay $108.47 to Elizabeth's counselor to be able to schedule the next session. And finally, the parties will appear back for support for review October 23rd, 2024 at 8:30 a.m. That is the recommendation. Ms. Herman, do you understand the recommendation?
Yes, Your Honor.
Are you opposed to the court adopting the recommendation?
No, Your Honor.
How are things going between you and Elizabeth right now?
Phone conversations have been great. We got to see each other on the 30th to do a little shoe shopping, so that was pretty awesome.
Good. And I know last time we talked about you wanted to be able to have dinner with her.
Yes. So looking forward to that.
Okay. Obviously, the counseling is important. So do you agree that you'll pay this sum to the counselor, the 108.47, pay that as soon as possible so we can continue that counseling, which is important in reestablishing the relationship between you and your daughter, Elizabeth?
Yes, Your Honor.
Okay. Are you still, these hours of 1 to 5 doesn't really give much chance for either lunch or dinner. It's like after lunch and before dinner. Are you still desirous of having dinner with her on Saturdays? We extend that to maybe like 6 o'clock.
I would love that.
Right. Obviously in a restaurant. To Ms. Rourke, any objection to giving mom more time on Saturdays so she can have a meal with her daughter?
Your Honor, I'll defer to my client. That was the time frame that Ms. Herman requested, and he agreed to that. Josh?
Yeah.
I remember last time Ms. Herman did request the opportunity to have a meal with her daughter.
Yeah, that's fine.
Will that give you enough time to have an early dinner then, Ms. Herman, if we change time from 1 to 6?
Yes, Your Honor.
And obviously, there's no reason why you probably know what the restaurants Elizabeth enjoys.
Yeah.
Like more time to another activity on a Saturday.
Yes.
All right, so we just if we make one modification, Mr. Pratt, to extend the Saturday party time from 1 to 6.
Absolutely, Your Honor.
Yeah. So with this recommendation, Ms. Herman will be picking up Elizabeth from Dad's house. Is that correct?
Yes, Your Honor.
Right. And obviously having a 14-year-old daughter, I'm sure she loves to go shopping as well. So if she needs the school closed, it's probably an ideal time to spend enjoyable time with your daughter, Ms. Herman, just a suggestion. Ms. Rourke, this revision, is this acceptable to your client?
It is, Your Honor.
Right. Anything further then this morning, Ms. Rourke or Ms. Herman?
No, Your Honor.
Your Honor, I would just note for the record that since we were here in court last, Elizabeth has been going to counseling. My client has encouraged her to communicate with mom. They did go shoe shopping last week. Elizabeth asked if that was something that she could do with mom. That did go well. And so my client is encouraging that relationship. He's hopeful that they will be able to continue to build on that progress with the assistance of the counselor.
Very well. Hopefully with the continued assistance with counseling, we can go back to normal parenting time. All right, so we'll put this back on our docket October 23rd, 8:30 a.m. Ms. Rourke, do you receive regular letters from the counselor updates?
Your Honor, I have not. My client's requested a written update from the counselor. He's not received that from her yet.
Okay. And obviously, there's nothing wrong with Ms. Herman talking with the counselor. Is that correct? She can reach out to her and inquire what she can do to reestablish a relationship with Elizabeth.
That's correct, Your Honor. Elizabeth's appointments historically have been scheduled on Saturday afternoons. That was something that we talked about today. Mom will take her to those appointments so that she can be involved to the extent the therapist deems appropriate with the actual sessions, but also so that she has I guess, easier access or can communicate with the therapist before or after sessions for any recommendations she might have for Ms. Herman directly.
Very well. Thank you, Ms. Rourke. Anything else you want to add, Ms. Herman?
No, Your Honor.
Okay, so Again, we've changed the parenting time session from 1 to 6 on Saturdays. We'll be back to review parenting time October 23rd, 8:30. Hopefully we can make some real progress between now and then. Right. Everyone be mailed copies. That will conclude this hearing. You can all zoom out, as well as our wonderful friend, the court representative, Erin Brower. Good morning, Ms. Brower.
Good morning, Your Honor.
Again, this hearing is being conducted via Zoom. The court has received the fine recommendation from Ms. Brower this morning. Recommendation is that parent time between mother and daughter will continue as previously ordered, which, if the court recalls, is every Saturday, 1 p.m. to 6 p.m. in a public place. Parent time will continue if Elizabeth, the minor child, is working on Saturdays or has agreed on a different date to give mother her 5 hours of parenting time per week. The issue of parenting time shall be referred to the front of the court for formal investigation and recommendation, with each party having 21 days in which to object to any recommendation, in which case come back before the court. If there is no objection, the recommendation will become part of the court's order. The child, Elizabeth, shall be interviewed as part of the parenting time investigation recommendation. Mother's interview shall be at 9 a.m. The interviews shall be conducted via Zoom on November 7th, 2024. This order does provide for a Zoom ID number for the front of the court. The person that will conduct the interview. Mother's interview will be at 9 a.m. Father's will be at 2 p.m. My child will be brought to the front of the court in person after school for her in-person interview. All appointments for the minor child shall be added to the app closed calendar at the time they are scheduled by their parent. The parties will return to this court to review all of this on November 20th, 2024 at 9:30 a.m. We will have at that time the front of the court's parenting time recommendation. Ms. Brower, is Ms. Scott still conducting those investigations?
No, Your Honor. Jessica Sisk is our parenting time caseworker, and she will be conducting the interviews and the recommendation.
Yeah, working with Ms. Scott?
No, Your Honor. Ms. Scott handles child support.
Okay.
Ms. Sisk is our parenting time caseworker now, and she handles all investigations.
Okay. I know Ms. Scott is getting close to retirement. I didn't know if she was, she's still here, but she's moved from custody parenting time investigations to child support. Is that correct?
Yes, Your Honor.
Okay, I was not aware of that. All right, Ms. Work, is this recommendation good with your client this morning?
It is, Your Honor.
Right, Ms. Herman, do you understand the recommendation?
I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
I'm having a hard time understanding why it's needed, but Elizabeth's not hopefully not going to hold back on some of the things that she wants to talk about with Miss Jessica. Hopefully it's some of the things that she's discussed with me and wanting to get back to normal, the normal 4-3 split.
Okay, well, this is an opportunity. Obviously, Elizabeth is old enough to express her preference and her thoughts and her concerns, and hopefully she will be forthright when she's interviewed. Obviously, neither the parent should influence Elizabeth, because it will come out in her discussions. All right, it appears appropriate to obviously, if Mr. Obviously, the court's always reluctant to put a child in the middle, but obviously, since the two of you cannot agree, then it's unfortunate. Elizabeth, I'm sure the last thing she wants to do is be interviewed by some court representative. But since your parents cannot agree, then that will happen. If you can reach an agreement between now and then November, we can always call off that interview. Obviously, Ms. Herman, you're wondering why this can't be done. Well, obviously, Mr. McDonald will not agree to any expansion of parenting time. And that's something you can discuss with him in terms of his reasons why.
over our messages on the app close, it was to my understanding that Josh was eager to get things back to normal. But here we are.
Your Honor, I believe that's a mischaracterization of Mr. McDonald's messages. Elizabeth is almost 15 years old. We're in this position because of Ms. Herman's actions. My client is encouraging Elizabeth to spend time with her mother. He has been accommodating to, adjust schedules and times for visits, and he is committed to continuing that. But Elizabeth is almost 15, and as a teenage girl, she has opinions that she has expressed to her father. According to Ms. Herman, she's telling her something different. And we believe that it's important for her to have the opportunity to speak with Ms. Sisk or a friend of the court in order to make a recommendation for parents.
Is Elizabeth still engaged in counseling?
Yes.
She is.
Okay. Ms. Herman obviously should talk with the Elizabeth's counselor to see what you can do constructively as a parent to repair that relationship and rebuild that.
Your Honor, I've been to 3 of the counseling sessions, and I have spoken with her as well.
All right. That should give you some insight in terms of where Elizabeth is.
Yes, Your Honor.
But no question, obviously, every young woman needs a mother, active mother in her life. It's critical. So, Mr. Herman, whatever you do to facilitate that, encourage that, please continue to do so. In any event, the court will adopt the recommendation. You both know the copy. Please note in your calendars the Zoom interviews with the front of the court on November 7th. Presumably, Dad will bring in Elizabeth to the front of the court after school on that date. Is that correct?
That's correct.
All right. Okay, and then we'll see everyone back here then to review parenting time on November 20th. That's a Wednesday at 9:30. All right, that will conclude this hearing. Everyone can zoom out, and that will have good rest of the afternoon. Good morning, everyone.
Good morning.
Good morning, Your Honor.
Parties have conferred with Ms. Patrick this morning, who has provided the court with the following recommendation: that mother's parenting time shall be every first, second, and third weekend of the month, from Friday after school or 4 p.m. if no school, until Monday back to school, Monday morning, or 9 a.m. if no school. The parties shall use the front of the court holiday schedule unless they agree otherwise relative to holidays. The parties will each have 1 week, uninterrupted summer parenting time with the dates to be agreed upon by June 1st of each year. Further, that all parenting time complaints will be considered to have been dealt with as of this date, as both parties have violated prior court orders. So that we'll start with a clean slate hereafter. Ms. Herman, do you understand the recommendation?
I do understand. However, I would like to have that 4th weekend as well. And because I haven't had any time at all this summer or up until this moment.
Well, obviously there's some issues between you and Elizabeth that prompted that breakdown for a period of time. But again, obviously Dad should have some weekend time too. I mean, your daughter's busy with school, Dad's working, so they should have some one-to-one time. So the court's not going to give one parent every weekend of every month. Now, I guess we can talk about if there's a 5th weekend. If there's some months that have a 5th weekend. So we'll discuss that in just a minute. Ms. Burke, is this recommendation good with your client, Mr. McDonald?
It is, Your Honor.
Any objection to if there's a 5th weekend that mother would have the 5th weekend?
Your Honor, I believe that there would be. Our initial request this morning was that the schedule be every other weekend rather than the first 3. Just there are some concerns lingering. My client is trying to be reasonable and has agreed to the 3 out of the 4 weekends. So we would request that the court follow the recommendation at this time.
Well, of course, the front of the court did conduct a formal investigation, which I believe included an interview of the child. And this recommendation appears to be consistent with that recommendation. unless you want to make the mother has the first, second, fourth weekend. Would that make a difference for dad?
I mean, I would just rather keep it how we, or what we agreed on.
I don't believe that the which of the weekends is dad's is necessarily the a deciding factor for Mr. McDonald, Your Honor. But he's
Okay.
requesting that the 3 weekends be given to mom, that be the order of the court.
Very well. The front of the court has investigated this matter and viewed the minor child. And this recommendation appears to be consistent with the front of the court recommendation to this court. We'll rely upon the recommendation in front of the court and is inclined to adopt this recommendation.
Your Honor, can I get some clarification for the summer? Would I still be first, second, and third weekend?
Correct. And if there's no school, then of course you'd your parenting time would be Friday at 4 o'clock and then 9 o'clock back to 9 o'clock on Monday morning. If there's no school, and that'd be in the summertime. If there's any issues, you can petition the court. Anything further this morning, Ms. Verka?
No, Your Honor, I don't believe so.
Okay. All right, teenagers are challenging, Ms. Herman, Mr. McDonald, and obviously it's important that Elizabeth have a relationship with her mom. So obviously you need to be aware and sensitive to the needs of a teenager, Ms. Herman. And Mr. McDonald, you need to obviously encourage a relationship between your daughter and her mother. She only has one mother and one father in this world. So it's important that both of you foster a good relationship between your daughter and the other parent. For example, making sure little things are big things, making sure that your daughter gets a Christmas gift for the other parent. Mom, you should encourage her to get something for Mr. McDonald. Mr. McDonald, likewise, make sure that Elizabeth gets something for her mom. Just those simple acts mean a lot to Elizabeth, that each of you respect the other. All right, with that, and of course, that will start presumably this weekend. And the two of you have to talk about Thanksgiving. You can both go online and get the Monroe County Front of the Court holiday schedule. Obviously, if we cannot agree upon Thanksgiving holiday, then the Front of the Court schedule will control. And mom's parenting time will start this weekend. So Friday after school. So dad, let her know that the mom's gonna pick her up after school on Friday.
Your Honor, I believe this would be the 4th weekend of the month.
Oh, I'm sorry. I'm looking at this month of December. I'm sorry. That's correct. This would be the 4th
Any
weekend.
harm in it starting this weekend?
I will leave that between you and Mr. McDonald.
Say that again.
Ms. Sherman is asking if she could have this coming weekend.
No, this weekend I already had plans set up. I mean, she did have her this weekend for her parenting time.
So does my parenting time for my 5 hours doesn't go towards this weekend? Per the last order?
Well, it's a good point. The prior order gave you a parenting time Saturdays from 1 to 6. So what plan do you have, Mr. McDonald? Why shouldn't she have this Saturday from 1 to 6? And this new schedule could start in December. It's a good point.
Well, I always do. This weekend would be what, Thanksgiving?
No.
Next.
No, the following week.
The following week? I mean, I would at least like to have a weekend where I can spend time with her.
Well, you spent the last 2 weekends with her. I mean, all right, the court's going to order that the mother shall have parenting time. We can clarify this, that this schedule, the mother's first, second, third weekend will commence with the month of December. And mother will have parenting time this Saturday from 1 to 6 per the last order of this court.
And then as for Thanksgiving, which is the following weekend, we'll base it off of the court's recommendation online.
Yeah.
Yes, Saturday the 30th. So you should have her, Elizabeth, on the next 2 Saturdays of this month, 1 to 6. And this recommendation of first, second, third weekends, that will start with the month of December. But the remaining 2 Saturdays of this month, Mom will have the parenting time Saturdays 1 to 6.
Your Honor, the last Saturday of this month would be the 30th, which would be covered under the Thanksgiving holiday at the front of the court holiday schedule.
Okay, and who has Thanksgiving this year?
That would be Dad.
Right. I'm going to be talking with Ms. Patrick about the Thanksgiving. So clarify some of these points are all valid points. I don't know when Ms. Herman celebrates Thanksgiving. If she wants, some part of that weekend, it would be reasonable. So Ms. Patrick, we can just talk to them another 5 minutes to see if they can. We want to clarify the courts. We'll order this first, second, third weekend commence with the month of December. And then mother out parenting time in the interim Saturdays 1 to 6. Just a question of whether or not what we're going to do with November 30th, which is part of the Thanksgiving holiday. So if you'd see if the parties can find some middle ground with respect to that, we'll put you back in the breakout room.
Okay. Thank you, Your Honor.
For the record, the parties have conferred with Ms. Patrick further this morning regarding parenting time for the plaintiff mother. Ms. Herman and Ms. Sawerka, thank you, Ms. Patrick, for discussing the issue further with the parties. The court has received a revised recommendation. Again, that mother will have the parenting time the first, second, third weekend of each month. This begin with the month of December 2024. Her parenting time will be on those weekends, Friday after school or 4 p.m. if no school, until Monday back to school or 9 a.m. if no school. In the interim, plaintiff mother will have parenting time November 22nd. So rather than after school, it'll be 4 o'clock.
Okay.
I know she gets off the bus at like 3:30, so I'd be
Okay.
showing up right around that time so she can get situated and everything.
All right, so the pickup and drop offs will occur at Dad's house. What about Monday? Are you take her to Dad's house to get the bus, or you take her right to school?
I would be taking her right to school. Granted that she still has all of her belongings. I'll make sure that she's aware that she'll be going right to school.
Okay, and so make that known to Elizabeth, Dad. And obviously, if there's any changes too, we need to communicate about that.
Yes, sir.
Yes.
All right. Court will adopt the recommendation. Thank you, Ms. Worker, for your continued assistance this morning. Thank you, Ms. Patrick. The court applies to we've reached your own agreement, so let's hopefully this will work, and mother can restore a relationship with her daughter. All right. If there's nothing further that could conclude this matter, I want to zoom out. Have a good rest of the morning.
Thank you, Your Honor.
Thank you. You too.
For the record, this matter was brought to the court's docket at the request of the Monroe County Friendly Court. This hearing is being conducted via Zoom. Is Michael Montry present on audio?
Yes, I am.
All right, good afternoon. Also present is Monroe County Friend of the Court, Patrice Patrick. Ms. Patrick, can you give the court some information regarding Mr. Montry? Obviously, he's delinquent with respect to a sport obligation. That's why he's being brought before the court.
That's correct, Your Honor. Mr. Montry will show cause today because he is not making the payments that he's required to make. He's also on felony non-sport on both cases. He has a 2015 UE, he has a 2010 DS. On the 2015 UE, he owes $12,826.14. On the 2010 DS, he owes $8,356.49. Under his felony, he is supposed to be paying $500 a month on the 2015 case. He's supposed to be paying $336 a month on the 2010 cases. He has failed to make these payments. Also, interesting enough, he told Ms. Brower, who spoke to him, that he does not have a license and he cannot drive, but I noticed when he came on, he was sitting in a vehicle. The friend of the court is asking for, he also has a contempt on both cases that he was found corresponding contempt on May 6th of 2019. Each case still has 28-day balance. Friend of the court is asking for 28 days immediately on both cases. And I would like $5,000 to be split between the 2 cases. That's the extent of the recommendation, Your Honor.
All right, to Mr. Montry, obviously, when you're brought to before the court, it's because it's a last resort when you're not complying with court orders. What's your current address, Mr. Montry? All right, so Mr. Montry, the court's ordering you personally appear in this court tomorrow, 11:15, for the courthouse.
Yes, sir.
And what the court's suggesting is you bring a significant amount of cash to make a payment toward your child support urges, or bring a toothbrush because you got 28 days to have your head. Ms. Patrick is suggesting $5,000, $2,500 each case. The court makes something less than that. A couple $100 will not do it. So you decide if you want to avoid spending the holiday, the next 20 days in jail, you need to bring a significant sum of cash. Just reach out to family and friends if you want to be home for the holiday. Any questions?
Yeah. If I can't come up with the 5,000, is there another amount that would be sufficient enough?
You tell me what you come up with. A couple $100 is not going to do it.
No, it would probably not be a couple hundred. be significantly more than that.
The court's thinking
I know I can make
$3,000.
I know I can make at least close to $1,000 payment on Friday when I complete this job that I'm on right now. So 2 weeks ago, I know you probably heard this excuse before. I lost my wallet. Somebody stole all my money out of my wallet. My wallet was returned with nothing in it. I've literally been going without everything, food, all that stuff. I'm really trying here. I'm not, it's not like I don't want to pay it. I want to get this done and over with. It's just been really hard on me. I honestly don't have a license or my own car. This was my friend's work truck that I was in, who gives me a ride back and forth to my jobs that I have to do. I was going to come in and make a payment a couple of weeks ago, and my ride showed up late to take me back home. I could not make it in there on time. After that is when I lost my wallet, and everything kind of went south from there. Like I said, I know I'm behind. I think it's probably like right around $1,200 right now, because I know I owe for the month of June. And like I said, I know
it's all noted for the record. All your excuses are noted for the record, but you're going to be here at 11:15 tomorrow. If you're not, I'll issue a bench warrant tomorrow. And with the court suggesting we bring $2,000 cash or a toothbrush. So they reach out to family and friends, and you can pay them back when you get paid on Friday. So that's what the court is looking at. So you pay $1,000 each of these two cases. The court's inclined to continue the matter. We're going to keep you on a short leash. So, but if you can't come up $2,000, then we're going to spend some time in jail. So the fourth floor, Judge Brown's courtroom tomorrow at 11:15. Okay.
Yes, Your Honor. And
I'd suggest if you want to avoid spend the holiday in jail, make that $2,000 payment in front of the court before you come up here.
Yes, Your Honor.
And you want to, all right. Anything further, Ms. Patrick?
Yes, Your Honor. I'd just like to make a note for the record that as of today, he owes $1,052. So we are in concurrent with the court saying he must pay at least $2,000. Also wanted to note to the court, he lives 4 blocks from the courthouse. I don't know why he had to wait for a ride and why he didn't just walk to the courthouse. That's all I have, Your Honor.
Okay. Well, you can walk tomorrow. Okay. All right. We'll see you tomorrow morning then, Mr. Montry. Now we'll conclude this matter. You can zoom out.
Thank you, Your Honor.
But we cannot ignore the law, the fact that parents have the ultimate authority. And there's a high burden for grandparents to overcome that if the remaining biological parents refuse parenting time with the grandparents. Difficult cases for this court and everyone. Parties have met with Ms. Patrick in front of the court this afternoon. She's provided the court the following recommendation that grandfather shall have grandparenting time a maximum once a month with a week's notice to the defendant father at the time he'll be in Michigan. For the record, I believe the plaintiff grandfather resides in the state of Kentucky. The grandparenting time will be for 3 hours each day for a maximum of 3 days, not to be taken consecutively. The grandparenting time will occur at the maternal great grandmother's home. That's the recommendation. It's a nominal time. I don't know how often grandfather comes to the state of Michigan. Let me ask Mr. Gorski, is this recommendation agree with your client?
It is not, Your Honor.
Okay. Mr. Bagley does not want his child, I believe it's his daughter, to have any time with the maternal grandfather. Is that correct?
That's correct. Not at this time. He's not ruling out something in the future, but not at this time, Judge. And to be honest with you, this child wouldn't know Mr. Cunningham if he walked into the room right now. She doesn't know maternal grandmother. He would be turning her over to people with whom she's unfamiliar. And that's at the heart of my motion to dismiss, that they have not carried their burden of proof.
Well, Ms. Moskovic, I know, of course, that there's also, you've prepared a subpoena to the minor child's daycare. Ms. Gorski has filed an objection to that. The court recognized, that there should be open discovery, but the court questions what will come out of that. I mean, it's like we have an elementary or high school student and we have attendance records. This is preschool. So I'm not sure, if any discovery result that's will make any difference.
Your Honor,
it
was a very specific request. We believe that the result of that would show who is taking the child to and from the preschool and who is the primary caretaker of the child. And that was the primary purpose of the subpoena. That being said, I think that, as you said, discovery is broad and it is not being done for the purpose of being intrusive or trying to gather personal information, but rather to gather information for the sake of this case.
Well, it's even if the court assumed that the defendant father was not the primary caretaker, would that still have a bearing on the ultimate decision?
But I believe that that's relevant.
Well, the court's not convinced that would make a difference in terms of the burden that the plaintiff must carry. And I presume, Ms. Wackowiak, your client agrees that Mr. Bagley is a fit parent?
Well, Your Honor, at this point, as Ms. Patrick has made the recommendation that she has, we would like to be able to establish even the most minimal parenting time. I believe that if we were to have to go forward and have a hearing as 7/22/27 permits, that would only create a further rift between the parties because of the evidence that would have to be put forward before the court. And so I'm trying to avoid that. We certainly can do that and put all the evidence before the court and meet our burden. But it seems like that would be counterproductive to the relationship of the parties.
May I respond, Judge?
Just one moment there. I'm just trying to find, there was a recent court of appeals, a case that indicated the court was not required to conduct a hearing.
That's correct.
I'm just trying to cite that case. So if the court makes a decision, Ms. Gorski, do you know the name of that case offhand?
I do. Judge, it's Throop versus DeVries. It's unpublished, January 7, 2020. And it states very clearly, I cited it in my pleadings, I believe, states very clearly that this, and I'm quoting, the statute specifically provides that at the hearing, the parties filing affidavits are allowed to be allowed an opportunity to be heard, but does not provide that the hearing must be an evidentiary hearing. And you are, in fact, allowing the people who filed affidavits an opportunity to be heard today, and nothing further is required. Ms. Wackowiak is not entitled to an evidentiary hearing, and that Court of Appeals number is 345987.
Your Honor, the Throop case was also cited in my brief, if you'll recall. And if you actually read the Throop decision, it did not rule that the pleadings were insufficient as the defendant suggests. Instead, the Throop hearing actually went on to the hearing on the issue of whether the grandparents had overcome the burden of showing the denial of grandparent time was a substantial risk to the child's mental, physical, or emotional health. So it actually did go forward to hearing. If Your Honor wants us to present you a copy of that decision, I absolutely can do that. So I don't think that that's necessarily an accurate portrayal. In every case, I did a thorough investigation, and there was not one case where the court dismissed simply based upon the pleadings without having some sort of hearing in the matter. And given that we haven't given the opportunity to get any discovery in this case, I believe that that is significant. In my opposition to the motion to quash, I actually cited the Varan versus Granneman case, which was cited. That was the case that they cited was Varan versus Granneman, which they cited for the proposition that grandparenting time does not grant legal custody to a child, to a grandparent, and involves a grandparent who was awarded grandparent rights after the hearing. But after the father's arguments to the contrary, the court affirmed the trial court's ruling that the grandparents had proved that a denial of grandparenting time would create a substantial risk of harm, again proving that they went to hearing in that case. And furthermore, I cited the case of In Re CADP, where the court considered the issue of whether the grandparents were entitled to information. And that was DHHS records. And they found that the only way that they could actually have the hearing on whether there was enough evidence was for the grandparents to be able to get the information from DHS in that case.
Okay. And I'm sure Ms. Wackowiak, court can permit a hearing if it chooses, but I don't think the court's required to do so. In terms of discovery, I don't know what other discovery you're contemplating other than these records from the preschool, the day spring Christian preschool. Let's just, if the court assumes for a moment, okay, that dad is not the one that's picking up and dropping off the child every day. And if you're suggesting, no, he's not the primary caretaker, I'm not sure what else those records are going to show. So even if the court assumes those records arguably show that he's not the primary person that picks up and drops off, what else would those records show?
Without seeing them, Your Honor, I can't even know what they would show. I mean, they could.
Give me a suggestion. I can't imagine that anything, those records would show anything that's relevant to whether or not the denial of grandparenting time would create a substantial risk of harm to this minor child. So I'm just not convinced in that regard. The primary question the court had, it seems like there's a relationship between the minor child of Mr. Bagley, Jillian, and her half sister, Drew. What is the maternal grandfather's current parent time with Drew?
Drew is
grandparenting time in that case?
Yes, there is time in that situation. In fact, Drew is going to be, the grandfather is here now, will be staying until Sunday, and he will be taking Drew back to his house for about a week. That is one of the things that we are very concerned about. In terms of Miss Zagorski's allegation that Jillian wouldn't know her grandmother, she stayed at her grandmother's house in August of 2023 with her aunt after the death of her mother. So she is familiar with these people, and she does know her grandfather. We have plenty of pictures of them together. They would spend Christmases, birthdays, family parties, plenty of time together. And it's unfortunate that we have gotten to the position that we are now.
So the last time Jillian saw Drew was in August of 2023?
October of 2023.
Okay. So how often does the maternal grandfather see or spend time with Drew?
Well,
once a year when he comes up to Michigan?
No, he sees Drew all of the time.
Okay.
He sees Drew quite frequently.
Okay. So it arguably could be in the best interest of Jillian to have a relationship with her half sister, Drew, but that's not really the issue before the court. The question is whether or not the relationship should be with the plaintiff maternal grandfather.
Well, I think that's twofold, Your Honor. One is that it is beneficial to have the relationship with the grandfather. They have a long-standing relationship of going to Christmas, birthday celebrations. She's been to Kentucky to see him. So that relationship is a strong one, but I do actually think that the relationship with the sibling or the actual maternal family, no one else from the maternal family can file a motion but for my client. So I think that he is the bridge between the maternal family, and that makes it relevant to whether it is in her, whether it is beneficial to her mental health to have a relationship. Mental, I believe the standard is mental, physical, and emotional health.
No question in this court's mind that this relationship would be beneficial to the minor child, Jillian. But the Court of Appeals has continually been consistent in their rulings that what might be good for the child is not necessarily consistent with the law and appropriate. The Court of Appeals, the court recognizes the Faulkner versus Stamps case, a 2015 case. It's a published Michigan Court of Appeals case in which the plaintiff asserted that if they were not permitted to have grandparenting time, the child would not have a contact. They went from her father's side of the family. The Court of Appeals says that argument is insufficient. The court cannot grant grandparenting time because it's good and that should occur. It's not sufficient. It's not a basis for grandparenting time under Michigan law. Again, this court must give deference to the decision of a fit parent. There's no indication that the defendant father is an unfit parent. It's presumed that his decision to deny grandparenting time does not create a substantial risk of harm, not a risk of harm, but a substantial risk of harm. Not just any harm, but a substantial risk of harm to the child's mental, physical, and emotional health. That burden is by preponderance. The court is not convinced that even discovery will permit the plaintiff to overcome that presumption. Accordingly, the court will grant the defense motion to deny grandparenting time. I regret to be beneficial to the child in this court's mind, but the fact that it's beneficial and good for the child and the maternal grandparent and is not will not withstand the guidelines provided by Michigan law. So I regret. Hopefully the parties can maybe communicate in the future, and there may be some possibility in the future, especially as Joan gets older. But obviously, the older she gets, the more distance these parties become. In any event, Ms. Gorski, you'll prepare the order.
Yes, should it include that the motion to quash is granted, or is that just assumed?
Well, is a motion to quash in this court's opinion is no longer relevant?
Okay,
it's
thank you.
moot. The court's opinion, the motion to quash is moot due to the fact that the court has determined even if court permitted that discovery, it would not make a difference in the court's decision.
Okay, I will prepare that order.
All right, that will conclude, so everyone can zoom out. Have a good rest of the day.
Thank you.
Okay.
Bottom of page 3, claim matter Fred Billmeyer versus Brittany Theobald.
For the record, this matter is before the court on the plaintiff's motion for the court to determine a family counselor for the minor children and the parties. This hearing is being conducted via Zoom. Present is Attorney Christine Hills, representing the moving party. The plaintiff father, Fred Billmeyer. Mr. Billmeyer is present. In addition, Attorney Leah Rourke is present, representing the defendant mother, Brittany Theobald, and Ms. Theobald is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon. This is read the briefs filed by counsel for both parties. Mr. Walker has provided this afternoon the court's fine recommendation that the father, minor child shall start family counseling with Armando at Tree by the Sea Counseling here in Monroe as soon as possible. Father shall contact Tree by the Sea and set up that initial appointment and give any information necessary to Armando regarding mother and the children. And presumably also notifying mother when that appointment was scheduled. That's a recommendation.
Yes,
Ms. Hills, is this recommendation agreeable with your client?
Yes, it is, Your Honor.
Ms. Rourke, is this recommendation good with your client this afternoon?
It is, Your Honor.
I'm sorry?
It is, yes.
Thank you. Will this counseling be primarily with the 12-year-old or both children? And then it'll involve the parents if the counselor agrees?
Yes, Your Honor. It will be. We anticipate it will be both children, and that the parents would follow the counselor's reasonable recommendations.
Okay, so be more of a family reunification counseling?
Yes.
Correct, Your Honor.
All right, wonderful. I appreciate your efforts, Ms. Rourke and Ms. Hills. Do you want to provide your respective clients regarding this recommendation this afternoon?
I do not need to, Your Honor.
I don't either, Your Honor.
All right, so Mr. Billmeyer, make those calls. It's just 3:30. Make those phone calls yet this afternoon. Get that counseling going as soon as possible. I know there's been a delay, but let's pick things up. What's the status of the domestic violence charge and against Ms.
That's been resolved through district court, Your Honor. I believe through a Spousal Abuse Diversion Act sort of resolution.
So stepmother's still on she on probation then?
I'm not sure. I'd need to ask my client if she still is at this point. Mr. Billmeyer?
She, I believe, has one more month left.
Okay. And I'm sorry, is there contact between dad and the children right now?
Not currently, Your Honor.
Okay. All right. So, and we need to get that moved as soon as possible. Do you want a review date?
Yes. Your Honor, our thought was because we don't know how quickly the family counseling is going to take to be effective. The children are in individual counseling. We're just getting started with the family counseling. We didn't want to schedule a review hearing and have that not be very meaningful. So I think that the consensus was that as things change moving forward, when we want to bring it back to the court's attention, then one of the parties would file a motion at that point.
Okay, or just even re-notice it for hearing. So I appreciate that.
Right.
Rather than wasting a hearing to date slot. So thank you. All right, the court will adopt the recommendation Copy will be mailed out to council. Now conclude this hearing.
All right, thank you, Your Honor.
Zoom out. Have a good rest of the afternoon.